Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content of these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.
Welcome to the podcast. Here's Beth Mulcahy.
Good morning, everybody. Welcome to our firm's live virtual First Friday event. I can see that we have people joining us as I speak, so welcome to all of you. Happy Friday. Thank you very much for joining us this morning for our firm's live virtual First Friday event. My name is Beth Mulcahy, and I'm the founder and senior partner of the Mulcahy Law Firm in Phoenix, Arizona. I wish you and your association a great 2024. I know we're already through the first quarter of 2024, so just starting the second quarter. Hope you've had a good first quarter so far. I've represented HOAs and condominiums in the state for over 27 years. My firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. Welcome to our firm's live virtual First Friday event. First Fridays are a great time to get your questions answered on Arizona HOA and condo law at no charge. Here's how First Fridays is going to work today. If you haven't done so already, please submit your First Friday questions in the Q&A box on Zoom or in the comment section on Facebook Live as soon as possible. And then I will answer every question between now and 10 a.m. Just a quick friendly reminder, because we received so many questions, especially today, this free opportunity is limited to one question per association. And if you plan on submitting a question live during the session today, please include the name of your HOA and condo and your current role when you submit your question. Also, please try to be as clear as possible in your question because with the virtual aspect of running the seminar, it's very difficult for me to ask a follow-up question live. So try to be as clear and concise as possible in your questions. Thank you for understanding. Okay, before we get started, I'm going to do a quick little legislative update. As you know, our legislature has been in session since January of 2024. This was a huge legislative year in terms of how many bills were introduced this year. I think we had over 23 bills, and maybe it was like up to 25 bills, 27 bills. I can't remember exactly. We had a number of bills that were introduced and a couple of things that are important, notable right now. There's 4 bills that have moved out of committees. The ones that have progressed are one on flagpoles, and 3 bills are also sitting with the governor right now to be determined whether or not they're going to pass this year. 3 of those bills are House Bill 2119, which is dealing with HOA fees and related parties, House Bill 2648, which deals with condominiums, planned communities, liens, and assessments, and House Bill 2698, which pertains to declarant control. We're going to be closely following those 3 bills that are sitting on the governor's desk right now. There are 2 bills that have been signed by the governor as of today, and those bills will become effective 90 days after the legislative session ends. We will continue to follow the bills that are signed by the governors. It's a trickle-down thing. So right now, there's 2 bills that have been signed by the governor. It's likely that 2 or 3 of the other bills that are sitting on the governor's desk right now will be signed this year as well. Each session going forward now, whether it's our neighborhood services, HOA Academy, or our First Fridays, we will be talking about the bills that are going to become law 90 days after the legislative session ends. So the first 2 bills that have been signed by the governor are pretty harmless from my perspective. House Bill 2141 deals with condominiums and interior improvements, and this bill would prevent the association from prohibiting a unit owner from improving or altering the interior of a unit in a manner that may disturb occupants that are adjacent to that unit if the unit owner purchases and installs at the unit owner's own expense any reasonably necessary improved materials, accessories, or other adjustments that eliminate or minimize the potential disturbance. So this is kind of an unusual bill. I had to guess probably there was a constituent that was upset about this, that lived in a condominium and their neighbor made some adjustments to their unit that potentially disturbed them. So we'll talk more about that bill as we get closer to the time that it is going to become effective. Second bill is Senate Bill 1432. This deals with unlawful restrictive covenants. This bill would permit an owner of a property subject to an unlawful restriction to submit an amendment to remove that restriction to the recorders or recordation in the lands office or in the county where the property is located. It permits an association to vote to remove an unlawful property restriction without a vote of the members of the association. A member or members of an association can request that an unlawful restriction be removed, and the association must act on that request no later than 90 days after receipt of the request. So actually, this is a good bill. Let's give an example. Let's say that an association has a provision in their documents that says something like no solar panels are allowed to be installed on lots in a planned community. Well, we know that there is a state statute that says that associations cannot effectively prohibit solar energy devices being installed by owners in a planned community. Basically, what would happen here is that the board would have the ability to remove that provision from the CC&Rs without having to do a vote of the membership. So truthfully, this is a great provision, and it's going to result in us being able to clean up our documents quickly when there are changes in the law that maybe conflict with our documents. So that's a good bill. There are other bills that haven't moved out of the committees. There's 23 bills right now that we're looking at. It's very unlikely that those bills are going to go anywhere this year, but we'll continue to keep an eye on them. So right now, the main bills are the two that have passed by the governor already and have been signed by the governor. We're watching the three other bills that are sitting on the governor's desk right now. So stay tuned. At our virtual HOA Academy, we'll be talking more about those bills, and we'll definitely have some answers to that. And that'll be on April 16th. Okay, let's get into our questions for today. We have 43 questions right now, which is probably a record, I think, in the history of our firm. So great that we have so many people here today. And happy Friday to anybody who is just joining us now. It looks like we have about 57 people on Zoom, and others have joined us on Facebook Live. So the first question is from a board member. Can you tell me what law or statute covers parking on or restricting the sidewalk in a gated community? So you're a gated community. So these are probably private streets in a gated community. And also important to note that the CC&Rs would probably cover this, not a law or a state statute. So if you're gated, that means that the streets are going to be owned by the association, and the sidewalk would be governed by the CC&Rs in the association. So more likely than not, there would be a provision in your CC&Rs, and there wouldn't be any state law or statute that would discuss that. Now, let's say that you're not in a gated community, then you may need to look at the city's ordinances to see what those ordinances are, and if any of those ordinances would cover, somebody that may be parking on a sidewalk. One thing to think about is this also raises fair housing issues in a planned community that might be gated, because if an owner isn't as handicapped and isn't able to use the sidewalk, to move from one place to another in your community because another owner is parking in a manner that's blocking the sidewalk, the association may have a duty to enforce that under the Fair Housing Act and make sure that that handicapped owner has access. Okay, next question from an association treasurer. Is it okay for a homeowner to address the board in open session at their annual meeting, or must it be done in an executive session? This is regarding assessment shortages. Okay, so you have a homeowner who wants to talk about, the finances of the association, maybe that there's not enough money coming in, it appears. So how I would recommend that this be handled is, if you're having a regular board meeting, have a homeowner forum at the beginning of the meeting and allow any owners that want to talk about any issue that's going to be, prior to the meeting, have them give their statement then. That would be my recommendation. Allowing the owner to interrupt an open board meeting, is not something that's typically allowed in a regular board meeting. The only exception to that would be if there's a motion and a second on the table, and then we are opening up discussion before the board votes on something. Under Arizona law, an owner would be allowed to contribute at that point based upon what the law says. What about annual meetings here? Annual meetings are the homeowners meeting, but the board also has business that needs to be conducted at the annual meeting. We have to approve last year's meeting minutes. We have to elect the directors. We like to have a president's report, a treasurer's report, maybe a management company report. And so it wouldn't be appropriate for a homeowner to be interrupting any of those agenda items. So what I also recommend for an annual meeting would be to have a homeowner forum during the annual meeting. So any owner who wants to talk would be able to talk at that time. These topics, having an owner make a, statement regarding assessment shortages as per your question is not something that would be appropriate to be done during executive session. Okay, question number 3 from a board member. We would like to have a did you know section in our newsletter that are quick info refreshers for our owners. For example, did you know you need an architectural change form to make changes to common area landscape or to the exterior of your building? We would have to quote the pertinent CC&R, or would we have to quote the pertinent CC&R verbatim, or can we refer to an article and section number of the governing document? Really, you can do it either way. I feel like you might lose people, though, if you quote the entire CC&R section, because those are pretty wordy and lawyerly and sometimes a little bit hard to understand. I think you could paraphrase it as long as the paraphrase meets the requirements of whatever the section in the CC&R says. Or you could just put the article and section number. That's fine. Or if you want to, you can put the whole CC&R section as well. Okay, question number 4. What is the process required for tallying ballots during the annual meetings? So we have a great cheat sheet on annual meetings. And I know, just kind of doing a preview of the questions today, we have a lot of questions on annual meetings, probably because it's annual meeting season right now. Typically the first and second quarter of every year where most of our associations are conducting their annual meetings. So what is the process that we typically see? Take a look at our cheat sheet on annual meetings, which we're sharing on Facebook Live and on Zoom. But really how it happens is there is no formal process that's dictated by law. I think what your board should do is determine prior to the annual meeting what process you're going to follow. It just also depends on the size of your association. If you're a really large association, like you have over 250 members, it can be a lot to tally all of those ballots at the annual meeting that evening, because typically the annual meeting only takes about an hour. And to tally that many ballots, it could take more than an hour, and we don't really want people waiting around, right? So what we typically do for annual meetings is we take all the ballots, that have been returned prior to the annual meeting. And so there's always going to be a return date on the ballot, right? We pre-count them usually the morning of or the day of the annual meeting. And we do a spreadsheet with all of the owners' names in an Excel spreadsheet, and then how they voted, whether there's multiple things that they were voting on, like let's say the election of directors, the last year's meeting minutes, whether they approve or disapprove them. We just tally them on an Excel spreadsheet. And then it automatically adds them up at the end on the Excel spreadsheet. And then we take that Excel spreadsheet to the annual meeting, and then any new ballots that come in person at the annual meeting, we hand count those. And that's a really efficient way to do it because it limits the mistakes that are made on counting the ballots. And it makes it really easy to, if somebody wants to review the ballots after the annual meeting, it's really orderly and organized. So that would be the way that I typically recommend. I mean, if your association is like 25 total lots, 25 total units, you most definitely could just count them too and bring a tally sheet with you that has, a listing of everything that you're voting on and then spaces to tally the ballots. Some important things to remember are make sure that you don't have anybody that has a vested interest in the outcome counting the ballots. Nobody that's running for the board should be tallying the ballots. None of their family members should be tallying the ballots. If you have a hotly contested issue like special assessment, and you have a number of people in the community that are for or against it, what you might want to do is have a representative from each group be there to witness the tallying of the ballots so that everybody feels that the tallying of the ballots was fair. But so there is no set process for tallying the ballots, but what I would recommend is that you talk about it before the annual meeting, in advance of the annual meeting, and that you come up with a plan and then follow it that evening. Okay, next question, number 5. Is it proper to have a design review committee of one person, the board president, who approves and disapproves all requests? So we have a cheat sheet on architectural committees and also on association committee basics. I guess my question is, why is there only one person who's on the architectural committee? In my experience, you're going to have an architectural committee that consists of 2 or 3 people, sometimes up to 5. And so it would be highly unusual for one person to be, approving or disapproving all the requests. If we're in a situation here where you have a requirement to have an architectural committee and we can't get anybody to serve, and that's why the board president is acting as the architectural committee, my recommendation would be just move this function to the board and have the board reviewing those architectural requests, because it is highly unusual and it's a lot of discretion for one person to be making the decision on this. And it's a lot of pressure too if they make a mistake, nobody to bounce ideas off of, et cetera. So if I were your association, I would move that task to the entire board and to act as the architectural committee. Okay, next question, number 6. From a board member, we are a 55 plus pet-free condo association that is not involved with unit sales except for the following information, which is sent to the title company for a new owner: CC&Rs, bylaws, rules and regulations, age verification form, and a number of other things are listed. However, we are not getting good compliance on these requests, and checking in on files when entering a new warranty deed copy, we're finding many unsigned forms. What can or should we do to get better compliance? Okay, so the title company has a responsibility to make sure that all of these forms are signed at the closing. So what's happening here is you have buyers who are buying, a lot or a unit in your association, and you're providing all this information as part of the resale disclosure statement to the title company. The title company has an obligation to fill out all of the paperwork, and make sure actually that the owner fills out all the paperwork and gives the paperwork to the new owner. Let me clarify that. The title company has the obligation to make sure that the buyer has filled out all the paperwork, and then the title company then returns all the paperwork to the association that we need signatures on. The title company also has the obligation to give the buyer all of these different pieces of information that were required by law to give the buyer, like the CC&Rs, the full disclosure statement, which lists how much the assessments are, a copy of the budget, a copy of the reserve study if you have one. And so it's really the title company that's screwing up on this. So what I would recommend is tell your manager or your management company to be very firm with the title company and let them know that every document needs to be returned to us signed. If it's not returned to you, you need to be following up with the title company to find out why it's not being returned. And it's their obligation to handle getting that back to you. Okay, question 7 from an owner. Squatters' rights, are they being canceled in Arizona like Florida? So we're seeing a lot of stories on the news about squatters coming into properties and trying to take control of the property and live in the property and, keep the owner from living there. I'm not aware of anything right now that's pending in the legislature. That really hasn't been on my radar this year. But if we find anything, that's a really good newsletter article that we'll be talking about and what associations can do if we have squatters living in there. So I'm going to have my team make a note of that, and we'll be writing about that in the future, because I love teaching these classes because it kind of gets my creative juices flowing in terms of what are some good subjects we can talk about. But I'm not aware of anything in Arizona right now that's pertaining to this, but I think based upon the national news stories that we're seeing from around the country, I think this is something that we're going to see more of going forward. Next question, number 8, from an owner, and actually from a former board member and one of my favorite former clients, who's now an owner. So our CC&Rs state that a homeowner can serve on the architectural committee. It is silent as to whether anyone, like a renter, can serve on any other committee in the association. The question is just that. If you are not a homeowner or unit owner, can you serve on any other association committee? I think that really just depends on what your documents say. If your documents are specific on this and it says that only owners in the association can serve on committees, then of course, only owners can. In your case, your CC&R state that a homeowner can serve on the architectural committee, but it doesn't say anything about a renter or anything else. So, ultimately, in your case, only homeowners can be on the architectural committee based upon what you're telling me. The board typically appoints the other committees, and if there's no limitation in your documents on who can and can't be in the committee, any committee other than the ARC committee, then your board can determine who the best fit is to be on the committees. In my opinion, though, really it should just be limited to owners because obviously they have a vested interest in, how things are run in your association because they are owners. So it would be really unusual to have a renter or a non-owner serving on a committee unless they had like some sort of special expertise that would be really helpful to the association. Okay, question number 9 from a board member. We have a homeowner who bought a long bed truck. It's too long for the driveway and it covers the sidewalk. Their alternate solution is to put it in the garage. However, the truck is too long for the garage. They now leave the garage door open 24/7, all day, all night. Any suggestions? What do your documents say about this? Do they say that the driveway owners can park on the driveway? Can it fit in the driveway? Obviously, having it cover the sidewalk is something that the board should not allow, in my opinion. Also, leaving the garage door open is something that I think the board should look into enforcement on. It appears that this is a violation, but I would need to see your CC&Rs in order to give you a more specific opinion on this. So reach out to our firm. We'd be happy to help you with this violation. But this does not seem like something that the board should just look the other way on. Okay, next question, number 10. We have a retired board member joining us on this question. How long must an HOA board retain its primary records, such as CC&Rs, bylaws, minutes of board meetings, financials? Who should keep them, and is copying all records to flash drives a good idea, and then destroying the paper records? So a lot of great questions on this on association records. We have a fantastic cheat sheet on community association records and documents that we're going to be sharing with you on Facebook Live and also on Zoom. That really gives a deep dive on records, how long you should keep them, what records, you can destroy after 6 years, what records you should keep forever. So quick rule of thumb, you should be keeping your CC&Rs, your bylaws, your minutes of the board meetings forever. Those are the history of your association, and those are not something that you should be destroying ever. Financials, it just depends by what you mean by financials, like copies of bank statements or year-to-date budgets, or maybe your actual financial statement. It's really up to the board. We can be sued for breaches of contract, meaning violating the association's documents. It's a 6-year statute of limitations, so I would keep them at least 6 or 7 years. For the financials, our cheat sheet gives you like a deep dive, like I said, on everything else, like copies of paid bills and that kind of thing. But most of those documents that are not the history of the association, most of those can be kept for 6 or 7 years and then be tossed. Can you put them on a flash drive? I'm a little wary about using a flash drive because those can be lost pretty easily. I would prefer that you put them in the cloud, anything that you're wanting to have scanned and kept on a permanent basis, because there would be a built-in backup system and there's no chance that you could lose them. Having a flash drive plus the cloud would be ideal, right? So a lot of associations are coming up with a plan to store all their records in the cloud. That's a very common thing that boards are doing, and getting rid of the paper copies. That's the norm kind of right now. Who should keep the records? If you're keeping paper copies, typically it's the management company will keep them. In some cases, our firm as legal counsel for the association is keeping the records for the association, as long as it's not too many records. But really, most associations are moving to storing their records electronically. That's kind of becoming the norm. Okay, next question, number 11 from a board member. According to our governing documents and under Arizona law, we are to have a yearly compilation of our financial records. I am a new board member and was just asked to serve as our association's treasurer. I asked our management company to send me the compilation for 2023 so I could review it. I was told the 2023 taxes have not yet been filed, and they are usually filed as an extension to whatever date that is later in the year. So just from a practical standpoint, that's going to be like September 15th for the extension. If you're filing your corporate taxes on time, you're filing them March 15th. If you get an extension, it's going to be September 15th. The compilation is done at the time of the completion of the tax filing. Is there any problem with submitting taxes as an extension and completing a compilation or an audit halfway through the next year? To my knowledge, we've never had a major problem in the past, so I may be worrying about nothing, but I am concerned about the timing of these two processes. So really, these processes are really separate. So there's really no correlation, in my opinion, between the taxes and your compilation of your financial records. It's fine to do an extension on your taxes. A lot of businesses do that. That's perfectly legal. You're filing state and federal taxes, just as long as you file the extension paperwork. And again, those will be due September 15th. Now, on the other side of this is your association's requirement to have a compilation done. Remember that state law in Arizona requires an audit, review, or a compilation to be completed within 6 months of your fiscal year ending. So if your fiscal year ended December 31st, that would mean that you have to have your audit, review, or compilation completed by June 30th. And then if any owners want to make a records request to see it, we would have to provide it within 30 days of the compilation being completed. And so, actually probably would be 10 days if they make a business request, a request to see the records. It would be probably the 10 days would kick in first for the corporate records. So I guess a couple questions that I would have for you is, do your documents require your bylaws? Do they require you to have that compilation, audit, or review completed by a CPA? If so, it does need to be completed by a CPA, and it needs to be done by June 30th, 2024 for the 2023 records. If it doesn't need to be completed by a CPA, really anybody can do it. So it could be a committee, it could be you as a treasurer, although you weren't the treasurer in 2023. It could be your management company, although the purpose of the audit, review, or compilation is to keep an eye on, and have a separation of powers. So there's some unknowns for me here. I would just say, just try to get it done as quickly as possible if you don't have the requirement to have it done by a CPA. But there is that date that you have to have it done by. So keep that date on your radar of June 30th. Question number 12 from a board member. Our HOA has a provision in the CC&Rs, and the CC&Rs are pretty antiquated. They're from 1979, controlling street parking on our city-owned streets. Do we lose that authority even if we had a meeting voting to continue control provided by the 2023 legislation? I'd have to know more about your associations, your documents and, your association to properly answer that question. But a couple of thoughts here. So it appears that you are a planned community, right? And that you have city-owned streets. And it appears that you have already had a meeting to continue controlling the parking, so it appears that you have complied with everything that you need to comply with in order to continue controlling your street parking. You probably need to have an attorney take a check of what you've done to make sure that you've done it properly. But it sounds to me like, you are aware of the law and you have taken the right steps. But to be safe, have an attorney look at that. Question 13 from a board member. An owner in our townhome community informed us their garage is flooding every time it rains because a neighbor built a paved patio, privacy wall, and changed the grading between their shared wall, causing water to pool against the shared wall. HOA did not approve the wall and patio. Is the HOA obligated to get involved in this? This is a really interesting question because there was a case that was recently decided by the Arizona Court of Appeals on this exact topic. And there's a case from maybe 10 years ago on the same topic. So a couple things. If an owner made a change to their property in your townhome community and looks like they built a paved patio, a privacy wall, and changed the grading, all of these things appear to be things that the association should have been consulted on. And by that, I mean that the owner who made these changes should have submitted an architectural application to the board. And so in my opinion, yes, the HOA board needs to look into this for sure, because it appears that the changes that they made are causing water to pool now into the other owner's garage. I do think this is an issue. There is a case from maybe 10 years ago that says the association does need to get involved in these type of grading cases where it causes water to flood another unit when one owner changes the grading and the other owner doesn't. And there's water damage to the other unit due to the other owner's behavior. The most recent case, though, that I was just released by the Court of Appeals, I think on Tuesday of this week, said something a little bit different, but those documents had language in there that didn't make it a requirement for the board to enforce that. So I'd like to look at your documents and give your association some advice based upon your documents as to how to handle this. But at first glance, I do think this needs further review. Reach out to our firm and we'd be happy to help you with this. Okay, question number 14 from somebody who is on a social committee. Can one board member oversee and vote on proxy for other board members? There are 4 board members. 2 usually let one board member vote for them. So this is not allowed, by a board cannot proxy their votes to another board member. So one board member, let's say they're back in Wisconsin for the summer. They can't say, oh, Johnny Appleseed, I'm going to just let you vote my votes all summer. That is contrary to the law. And, I'd have to look at your documents, but I doubt your documents would ever allow that. And it's just not something that should be done. And it's not legal. So the vote wouldn't be legal. Okay, next question, number 15 from a board member. Is a homeowner obligated to pay into a special assessment for an improvement for which they went ahead and received architectural approval to engage a contractor to have it done themselves on their own? Okay, so does a homeowner have to pay a special assessment for an improvement for which they went ahead and received architectural approval to engage a contractor to have it done themselves on their own? Oh, okay, I think I see what happens here. So maybe the owner did something on their lot by their own choice, right? And now the association is doing something similar for the entire community. And the question is, because that owner already paid for theirs, do they have to pay a special assessment for everybody else to have the same thing done? This is kind of a tough call because I don't know enough information about the special assessment. And I don't know if there was some sort of a deal when that architectural approval was granted by the board for the owner who already did the work. So there's some unknowns here. Generally speaking, a homeowner is going to have to pay a special assessment that's levied against association members. That's my general answer, but maybe there was some sort of special sweetheart deal with the architectural approval. So reach out to me and let me know more facts on that one. And that may be a reason for them not have to pay the special assessment, but more likely than not, they would have to pay it unless there was some other special side deal. Okay, question 16 from a board member. Our management company representative had the board meet to vote on a couple of items that needed more information, then ratify the votes at the next meeting. That is not how it works. Am I correct? I am well aware of open meeting laws and have informed the rest of the board and the representative. Okay, so this is a good open meeting question about the open meeting law. So apparently the board met to vote on a couple of items that needed more information. So it sounds to me like maybe they did this and didn't comply with open meeting law. A quorum of the board was meeting. They were discussing association business and actually voting on it. And then there hadn't been the notice requirements of 48 hours notice to the membership. And then after the fact, the board ratified the decision. I mean, I guess what I would say is this is not, consistent with the open meeting law, although I don't really know all the facts here. Was it an emergency? If it was an emergency, maybe this is okay, as long as meeting minutes were taken for the emergency meeting and those minutes were attached to the next open meeting showing why we had to take a vote and it was an emergency to fully comply with the law. I think what I would do is just share a cheat sheet with them. We have a great cheat sheet on the open meeting law. You may want to take that back to your board or your management company and just don't be confrontational. Just say, hey, I'm worried. I went to the seminar and we talked about this issue at this First Friday seminar. And I have this publication that talks about the open meeting law. I'm a little bit worried that if we're making decisions outside of a properly noticed open board meeting, that we could get ourselves into trouble. Now, if the management company pushes back and says, oh, you can do this, there's a state statute in the Nonprofit Corporation Act that allows you to take and make decisions by unanimous written consent. I just want you to know that our firm does not support that. There are at least 2 cases that have been decided by administrative law judges in Arizona that say that using that unanimous written consent provision in your documents or in the Nonprofit Corporation Act is contrary to the open meeting law, and the Planned Communities Act and the Condominium Act open meeting law would control there. Okay, next question. Number 17. Can you go over the court case you described last year where the court clarified its guidelines for the required percentages of votes required to change CCNRs? I'm going to share a link with you on where we've talked about this topic in the past. So this is the Kalway case. It's Kalway versus Calabria Ranch. This case is kind of a complicated case, and it's frankly not good law, in my opinion. I think it will be fine-tuned by either the legislature or by the Court of Appeals of the Supreme Court of Arizona in the future. The case didn't really talk about the percentages of votes required to change CCNR. Maybe you're thinking that the court was requiring 100% approval or something like that. Check out what we're sharing with you right now in the chat. I think it's a YouTube video where it answers the questions on this case in the past. It kind of gives more of a deep dive. We also have a couple blog articles that we've written on this, but here's the bottom line on the Kalway case. It makes it more difficult for associations to amend their CCNRs. The case had weird facts. It was a very small association, and the weird facts contributed to kind of the bad law that came out of it. There were very few owners in this association. A couple of the owners teamed up and passed an amendment to the CCNRs that negatively impacted the other owners. There was like 3 or 4 owners in the association, and a majority of the owners teamed up and passed this restriction in the CCNRs that negatively impacted the 3rd or 4th owner. They never told that owner about the amendment, and it negatively impacted this person, this owner. So of course the court was upset about it. So the ruling in that case is that amendments to CCNRs need to be foreseeable, which means would all owners foresee that this is the type of amendment that could happen? It also talked about the fact that amendments need to be reasonable, and it gave the court the ability to strike out any amendments that, the court didn't deem as fit or not reasonable. So it gives the court a lot of power. I think this case is going to be overturned. It doesn't mean that we have to get 100% approval on every amendment to the CCNRs based upon the Kalway case. What it means from a practical standpoint is if your association is going to amend its CCNRs, please reach out to us to discuss it, because there are some things that we can do to limit our liability. I encourage you to look at our publications and our videos on the Kalway case and reach out to our firm to discuss it if your association is thinking about passing an amendment to your CCNRs. Okay, next question. Number 18 from an owner. The CCNRs state the Board of Management shall consist of 3 members. The bylaws state at least 3 and not more than 5 members. The Articles of Incorporation states the board shall consist of 5 and not more than 7. Which is correct? Okay, so this is a great question. Basically, there's a hierarchy of documents under Arizona law. And so the hierarchy goes the plat, the CCNRs, the articles, and the bylaws. So the hierarchy dictates what should be the correct answer here. And under the hierarchy, the CCNRs are higher up. They're above the articles and the bylaws. So it's a Board of Management should be 3 members. Something you might want to think about doing is amend your other documents so that they're all consistent, so there's no confusion on this going forward. Question number 19 from a board member. What is the most effective way to control door-to-door salespeople in our community? Even though we're gated, they tailgate in, and we're being swamped by somewhat rude window, pest control, painting salespeople. Okay, well, a couple good things. So you're on the board and you're a gated community. So first, make sure that you're posting signs at your entrances saying no soliciting. That's number 1. Number 2, if you have these people coming into your community, call the police and they will be removed by the police. Hopefully the police, will come out and they don't have anything that's more pressing at the moment. The other thing that you could do is if you have the business cards, this is typically what happened. They put door hangers or flyers or whatever. You could send a letter, have your management company or your law firm send a letter to the companies, letting them know that there's no soliciting allowed in this community and they're trespassing. And that should also get rid of the problem. Okay, next question, number 20 from a board member candidate. Our HOA has just transferred from builder run to community run. It is a planned community. What came up in our first election of 5 new board members was this. Our CCNRs state 1 vote per lot or property. not one vote per registered property owner. The question that came up over and over among us is one voter per lot the norm? Okay, so a couple things I want to mention. So you are just transitioning from, developer to homeowner control. I would really recommend that you take a look at our cheat sheet on transition from developer to homeowner control. It's on our website at mulcahylawfirm.com. Just go to our cheat sheets, look in the, the search engine under the cheat sheets, and it should pop right up. Again, it's called developer to homeowner control. Talks about the most common issues that come up during that transition process. Okay, now you're coming up on your question with, you're electing your first board. It's your CC&Rs say one vote per lot. I'm not really sure what the distinction is that you're raising. So if you have 100 lots, there should be 100 votes. And if two people own a lot, they only get one vote. If they can't agree, the two people who own the lot can't agree on the vote, you can't split it. So, then I guess the vote doesn't count. But I'm not quite sure what you're saying. So you're saying our CC&R state one vote per lot, which I agree with. I just explained that. Not one vote per registered property owner. I think I covered it. So if you have, 5 owners that own one lot, they only submit one ballot. If they can't agree on how to vote it, it gets tossed out. Okay, next question is from a board member. We have 2 board positions open for the past year. 2 owners ran for these 2-year term board positions in the recent annual meeting elections. Unfortunately, a quorum was not reached and the board chose not to hold a second meeting. The board will appoint these 2 people to the board, which I think is a great idea. Thumbs up. That's exactly what I would have advised you to do. But our property manager says they can only be appointed for 1 year per industry standards when a quorum is not reached. Our bylaws indicate that an appointment is made to fill the remaining term of the position. I don't see how a lack of quorum changes the terms available. What do you think? 1 year or 2-year appointment? The one thing I would need to know on this is, first of all, your documents are in control, not industry standards. However, maybe the management company is thinking along this line. Okay, apparently you have a 5-member board, right? You have 2 board positions that were open for the past year. I don't know what the term was for those 2 board positions. How much time did they have left on their terms? It looks like you either have a 1-year or 2-year term based upon what you wrote in your question. So for those board positions that were open, was it their time to be reelected, meaning that they would have gotten a 2-year term? Or did they still have only 1 year left on those open positions? So let's say that the term still had a year left. If your bylaws say that an appointment is made to fill the remaining term of the position, if the position that these 2 people are being appointed to still had a year left on their term, you have to go back and look at the minutes from whatever the meeting was, then maybe they only got a year. If, their term was up, those 2 positions, the term was up and, you have a 2-year, term for board members, then it would be a 2-year term. The things that I would do is look at the annual meeting minutes for those 2 positions, find out those 2 people that resigned or left or whatever that created the vacancies, those positions, how much time did they have left on their term? And that's going to be the answer for you, because your bylaws say the appointment is made to fill the remaining term of the position. And if, those 2 seats were up for election, then it probably is 2 years. And if you want me to help you on this, just reach out to me and I can help you figure it out pretty easily. Probably, 15-minute phone call max, as long as I have the prior CC&Rs or prior meeting minutes. Okay, question number 22. If we had an open house coffee and donuts in our clubhouse for owners to meet and mingle with board members, would that violate the open meeting law? It really just depends. Probably not, because it sounds like a social event and not a board meeting where the board is, a quorum of the board is meeting to discuss association business between all of them. This sounds like it's in your clubhouse and you're basically just mingling and having donuts, and the quorum of the board isn't in a circle talking about the tree trimming project. So probably not, but I'd have to hear more about how that meet and greet was handled, but probably not. Okay, next question, number 23 from somebody who is an accountant for a single association. Can an owner successfully sue to stop an absolutely necessary assessment? So short answer on that would be yes. Basically, anybody can sue, right? That's just unfortunately kind of how it works. Can they be successful in suing on it? I mean, it just depends. Like, did you follow everything in your documents that was required to, levy the assessment? If you didn't, then they may be able to stop it. So if you didn't totally, perfectly, properly follow whatever the requirements were to levy that assessment, then yes, there probably is a chance that they can stop it, and the court will say that we didn't do it right, so we can't collect it. That's just a good reminder that whenever you're doing something that's absolutely necessary, or really any sort of special assessment or an increase in an assessment rate that you think might be challenged, bring in your legal counsel to help you oversee that process so that you don't have something like this happen. Because I have seen this happen with associations. They'll come to me after the fact and they did it wrong. Maybe they didn't pass the special assessment correctly, or they raised the assessment rate higher than the statutory requirement or the requirement that's in their documents. And an owner sues, and it just digs a really bad hole for them to get out of, because typically the owner will get their attorney's fees. So you're going to be minus whatever their attorney's fees were for the lawsuit. And you're not able to move forward with collecting the assessment. You have to go back to the drawing board and do it the right way before you can collect it. So it's a delay and it's expensive. Okay, next question, number 24. Our current management company is intimately involved in the scheduling, posting, and maintenance of board meeting agendas and minutes. How can the board go about searching for a new management company without the current management company getting wind of it? I've answered this question actually a lot over the years, and I'm going to recommend to you, we have a video on our website. Just go to our helpful video section. And I think it was like how to effectively work with management companies. And I talk about this at length in this video. So I would recommend that you take a peek at that. And our website's mulcahylawfirm.com. Okay, here's the bottom line. It's going to be really hard to search for a new management company without the current management company getting wind of it. So a couple things you could do would be the board could post the agenda for the meeting and conduct the meeting without the management company being involved. So I'm going to call this like the sneaky approach, where you put up the agenda or notice the meeting and don't tell the management company. There's a high probability they're going to find out about it from somebody, and they're going to be upset, and then they may fire you, take the lead on it and fire you. I've seen management companies do that. So just know that if you do that, just beware that that's something that could happen. Another approach would be to tell the management company, hey, we want to bid out the management contract, and we still want you to bid on it. And, that way you're telling them that, hey, we're testing the waters. We want to do our due diligence, our fiduciary responsibility to make sure we're paying the market rate. And we want you to bid, but we're also going to bring in a couple other bids. So that way you're letting them know that you're bidding it out. You're not sneaking around, have no intention of hiring them. There are a couple of results that could happen. Hey, they may up their game and start doing a better job, or they may just totally check out, right? I don't know. It just depends. But if you're in this situation, you really should be reaching out to our firm, because we've handled a lot of these changes in management companies successfully. I have worked with a lot of associations over the years, and I am familiar with the management companies in the Valley. I've had good experiences and bad experiences in the transitions. And if you tell me the name of your management company, we can strategize based upon my experience. That's the best way to handle it with them. And so I encourage you to reach out to me and talk about it. Looks like we just shared the video. My team is amazing. I'm giving them surprises this morning. Go search for this video. And we have a lot of videos on our website. So it's great that they were able to find that quickly and post it here on Zoom and Facebook Live. So I encourage you to take a look at that video and also consider reaching out to our firm to help you on this. Okay, next question, number 25. From a board member, my association is a PUD or a planned community. However, our units are single family attached. We have front yards that, while are owned by the residents, have an HOA service area where we provide water, plant, tree, and turf maintenance. A resident recently altered their front yard, including the infrastructure irrigation piping that runs from yard to yard underground and services the entire community. While the documents are very specific about not altering, digging, and making changes, including irrigation, how do we determine who actually owns that CCNR-imposed communal irrigation system? Wow, this is a great question. So what I would recommend, and I think this is from, I think I may be your legal counsel for this association. We need to look at what your documents specifically say about the front yards in terms of who maintains what and who's responsible for the irrigation lines. And then if the owner somehow made a change to the infrastructure irrigation piping, that may very well be a violation. They may need to put it back. So I think we need to do a deep dive on what your documents say and what the owner actually did. I would recommend that you have our irrigation company go out there and look at it and give us some information about what exactly was done and how it may have negatively impacted our entire system and whether or not this is something that's okay. You probably do need to get legal counsel involved. Okay, next question, number 26. We are considering revisions to our governing documents that currently allow the board to make decisions and take action by unanimous written consent in accordance with Arizona law. When does Arizona law allow boards to act by unanimous written consent? And are there any court or administrative decisions that provide guidance on this issue? So we kind of talked about this question a few minutes ago, and I see you're a board member asking this question. So as I said before, I do not believe, it's my opinion, that associations should not be using unanimous written consent with reliance on the Nonprofit Corporation Act. There's a section in there that talks about that, or with reliance on your association's documents, because unanimous written consents, in my opinion, violate the Arizona open meeting law. There are 2 law cases that have been decided on this issue. If you want to reach out to my firm, I have to do a little digging. I can find that for you. Just email me at bmulcahy@mulcahylawfirm.com. The only exception that I would have to this, where a board could make a decision outside of a board meeting, without giving 48 hours notice, is in the event of an emergency. And that's supported by the open meeting law. Okay, next question from a board member, number 27. We have a disgruntled and mentally ill homeowner who has sent abusive emails naming specific board members. This owner has misled other residents who have also now threatened board members, either verbally or by email. At what point should board members consider comments such as entering board members' units or decking a board member as actual threats of concern that would require taking legal action? So we have a great cheat sheet on this exact topic, dealing with difficult people and harassment, that I would encourage you to take a look at that, because we talk at length about what is considered harassment and what you can do under the law if an owner is making threats against you. Take a peek at that cheat sheet. Be sure to join us for our seminar on April 16th, which is class number 4 of our 2024 virtual HOA Condo Academy. In this class, we're going to be providing tips for managing difficult situations and handling difficult owners. I do consider the comments of somebody trespassing into your unit or decking you as serious threats. There's a couple different ways you can handle it. I would recommend that you reach out to your legal counsel. Maybe legal counsel should write a letter to these owners. Another alternative would be to go to your local justice court and get an injunction prohibiting harassment against these owners so that they would have to stay 50 feet away from you at all times. Our cheat sheet details both of those different options, so I would encourage you to take a look at that or reach out to our firm so we can help you with this situation. Question number 28 from a board member. Our association's CCNRs were last amended in 2019. The board intends to review this document to determine whether amendments can produce updated and clear guidance. As the board approaches the CCNR review, how important is it to maintain the grandfather clause regarding minimum rental terms for homeowners' residences? That was part of our 2019 CCNR amendments. And that they stated, provided that any owner as of January 4th, 2019 may rent or lease his, her, their, or its residence for a period of less than 60 days. However, that such right to rent or lease the residence for less than 60 days shall terminate upon the transfer of title. for the owners who are the owners of record at the time of the adoption of this provision. Okay, so you have an amendment to your CCNRs question. Looks like they were last amended in 2019. It dealt with a grandfather clause for minimum rental terms. I mean, I guess my question is how do people in your community feel about this? Typically, when you have a grandfather clause, it is because people don't want that right taken away from them. And so they wanted the right to lease a residence for less than 60 days. Any of the owners that approved this in 2019. So I think probably what I would do if I were in your situation is determine how many owners fall into this category. Maybe you have 50 owners, and let's say there's been 10% turnover since 2019. So maybe only 20 owners this applies to that are grandfathered. Ask them, is this important to you? Because you're probably going to need their votes to make this work. So I think talking to those owners is going to be really important before you just go and take that out. Also, these are controversial amendments. And if you ask me what my, nudge inclination is on this, it would be don't take it out because it's going to upset people. But ask the people yourselves, just do a poll or reach out to them and find out. Okay, question number 29 from an owner. What to do when our management company says it's too difficult to give me copies of invoices spent on roof and pool repairs. She wants to charge the HOA $75 an hour to provide them. The board has not been receiving the invoices, only the estimates or bids. Going forward, the board is to receive them and they will then provide copies to me. I'm trying to keep records for the board instead of the management company being the only ones with the copies of the large expenses. Okay, there seems like some dysfunction here. Okay, you're an owner and a couple things. So it shouldn't be too difficult for the management company to give you copies of invoices because they had to get an invoice to pay a bill, right? So there should be like a paid invoices area for that vendor. So this shouldn't be that difficult. So I think that's odd in my opinion. Most management companies will keep that in a special lock file for the vendor, and then every invoice just goes in there. The management company just throws all the invoices in one place. If you're a small association, there shouldn't be that many invoices. So I think it's odd. It's going to take her $75 an hour to provide them. That just seems a little bit over the top and, question mark around that. Maybe she doesn't have them, or maybe there weren't any. It sounds weird. Apparently, the board also didn't receive the invoices and only estimates or bids. So if I had to guess, probably she just paid up estimate. And that's fine. That's the case. That's something how things are handled. I guess going forward, I would just say you are entitled to see them. They can charge you 15 cents a page. If the manager is charging that much money to pull the documents, I mean, that's probably part of the management contract, but it just seems odd that it would take that much time to pull these documents. You being the person that is keeping the records of the association as an owner, that just seems odd. That's why we're paying the management company. So I don't know, maybe it's time for a change in the management company. Things aren't sounding exactly right to me. Question number 30 from a board member. What can you tell us about the new law coming regarding the number of full-time residents in a cooperative or RV mobile home park? Our office did, after we got this message, we did call the Arizona legislature this morning, and we were unable to locate this bill. So we'll need more information from you. So if you can email me, I'm happy to look into this and can give you more information on it once you tell me a little bit more about it. Okay, and this is a little different. Let's just be clear that cooperatives, RVs, and mobile home parks are not considered condominiums and communities. I'm not a specialist at all in mobile home parks. That's not an area that our firm dips its toe in the pool in. We do have a few cooperatives. There aren't very many in Arizona, but we do have a few cooperatives in Arizona that we do represent. Okay, question number 31 from a board member. We normally invest our reserve funds in FDIC insured money market and CD accounts. One board member wants to invest in more aggressive or lucrative investments such as bond funds. Does straying from tried and true money market and CDs open us to claims of a breach of our fiduciary duty? I think the key thing here is anytime that you are investing the association's money, it needs to be in the safest possible investment. And so my opinion is that most associations are putting their funds into CDs that are FDIC insured. I don't know enough about bond funds to give you a good opinion as to whether or not they're safe or not safe. But if you meet with an investment advisor, they can give you a more detailed analysis of this. I think that the question is, what is the difference between investing in a bond fund versus investing in a CD? I mean, the rates on the CDs have been amazing. They've been like 4 or 5% the past year. And those are going to go down in terms of the interest rates going forward. But I mean, that's a pretty good return, frankly, and it's safe. So I don't know very many associations that are looking into more aggressive type returns. But I think you need to weigh what the risks are between a bond fund and putting the money in a CD that's FDIC insured. And after you talk with a investment advisor, you're always welcome to reach out to our firm to talk it through with us. I will say that 95 to 100% of our clients they're doing CDs right now because the interest rates are so high and it's such a safe investment. Okay, we're on question number 32. And one follow-up question on the question before is, I don't think it's necessarily a breach of your fiduciary duties as long as you're looking into it and making a good decision. You're exercising the duty of care. But again, be careful because we don't want you investing anything that's high risk. Okay, we are on question 32. We have 54 questions today, so we are moving right along. Question number 32. What can be done about cars that are parked overnight continually? So we have a great cheat sheet on enforcement of governing documents. What I would do if I were looking at this situation is I'd look at your CC&Rs. What do they say about cars being parked on streets? Can you bring in a service to start ticketing these cars overnight? Is towing allowed? Can you put a boot on the cars that are parked illegally? There's lots of different things that you can do as a board to enforce on-street parking. Of course, the law is changing on this. So if the streets are owned by the city, dedicated to the city, this whole parking on the streets may be changing for your association in 2026. So lots of different changes on street parking for streets that are dedicated to the city coming in the future. Check out our cheat sheet on enforcement of governing documents for some tips on how you can enforce it through finding the owner, considering a lawsuit, going to the ADRE, having your attorney send them a letter, towing. All of these things are some things that might be able to be done by your association, depending on what your documents state. Okay, next question, number 33, from a board member. If a member quorum is not achieved for the upcoming annual meeting, does the current board remain as the 2024 directors, and can the general and executive portion still be held? Great question. If you don't have a quorum for your annual meeting, there's a couple things you can do. You can try to renotice it again and try to get the quorum at the second meeting. Sometimes you have a lower quorum requirement for the second continued annual meeting. Or sometimes the board just says, we're not going to try because we have a very hard time getting a quorum. So typically what happens is the board that's in place prior to the 2024 annual meeting will continue forward as the 2024 directors. And I'd have to see your documents to 100% tell you that. But typically what happens is you are elected to the board until your replacements are elected. So you will stay on the board. And so the next question is, well, if we don't have a quorum at the annual meeting, can we still have an informal type meeting where we talk about the general issues, but we don't actually elect directors? Of course, you can do that. And at the end of that, you can have your after meeting and elect the officers for the next year. That should not be done in an executive session, though. It should be done in an open board meeting. So you would need to notice that 48 hours in advance, too. So let's say you're scheduled to have your annual meeting, in a couple of weeks. You don't get a quorum at the annual meeting, but you still can have an informal meeting that night of your owners. It's just not going to be considered a formal annual meeting because you don't have a quorum. The directors who are in place right now will continue forward. And, if you're going to have a meeting to figure out who's going to be officers for the 2024 term, make sure that you notice your regular board meeting for immediately following the annual meeting. So 48 hours notice so that you do that correctly. Okay. Next question, number 34. We just got a new property management company selected by the board. And this question is from a board member. President who has a good relationship with the property management company talked to the property management made some changes in the management contract and updated it so the president signed the contract and then asked the board to sign the contract. The treasurer asked the board to list the changes and indicates that it requires new board approval. The president signs the contract without board approval, and other board members don't support the treasurer. What can the treasurer do? This is a sticky wicket for sure. So you have a situation with some dysfunction on your board, right? My opinion on this is your legal counsel should have reviewed the management company's proposed management contract, number one, and then given recommendations to your board as to if it was okay or if there were changes that need to be made. Technically, the president shouldn't just be making this decision. The board should be looking at the recommendations of the attorney, and then in an open board meeting or an executive session based upon legal advice from an attorney, they should take a vote as to whether or not to approve the management contract. And if there are any changes to be made, agree on those changes. So it appears that this wasn't handled properly. What are you going to do about it? Well, the contract's already signed and the president probably has apparent authority. And, you don't really want to start off with the management company on a really bad foot by trying to void the contract, put your association in a really bad situation. In my opinion, I think that your board needs a boot camp where you guys can talk through some of these dysfunction issues. And so our firm does these all the time. I've done one this week. I think I'm doing 2 next week. It's a really good time when you have a new board in place, or maybe you're making a transition like to a new management company, to get the board together and talk about, what does the law say? What are some issues that we're having as a board? How can we work together effectively? And I oversee it. And I can tell you truthfully that I've done hundreds of these over the years. I have never had a board that didn't walk out of a boot camp operating at a much higher, more functional level without a bunch of dysfunction. So we talk through the issues, we work through things, and it's basically like an hour and a half time. So I really recommend this for your association. Okay, next question from a director, question 35. Can a board with a 67% vote of owners place in their declaration that the condo board can vote by a majority, another vote? Let's see, this question isn't worded very well. Can a board with a 67 vote of owners place in their declaration that a condo board can vote by majority another board member off the board for non-attendance, not fulfilling their role or being disruptive to the board? Or once owners vote in a board member, it's only the owners that can vote them off? So we have a cheat sheet on this topic. It's the top 10 things you need to know about Arizona law. Number 6 is how to remove a board member from office. Generally speaking, a board member in Arizona can only be removed from office by a vote of the membership at a special meeting that's called for that purpose. In some situations, if your documents allow for like an automatic resignation, if the board member misses a certain number of meetings, that may be applicable here. But I'd have to look at your documents to let you know. But generally speaking, you do need a vote of the membership, not the board membership, the membership of the entire association to get rid of a board member via the removal process. And we just shared with you the cheat sheet on the top 10 things that you need to know. It's number 6 on there. Okay, question number 36. Thank you for all of you for being here. Okay, question 36 from a board member. We allow 1 lease per 12-month period after the property is owned for 18 months. Are we able to require the landlord or homeowner to provide proof of registration with the City of Scottsdale and Maricopa County Assessor's Office, proving that they are a legal entity? This would give us one more tool in controlling rentals out of compliance with their CC&Rs. Okay, so a couple things. There's only certain things that we can require on rentals, and we have a cheat sheet on, managing rentals in a community. So take a look at that. It's on our website at mulcahylawfirm.com. I think it's called like dealing with rental properties or rental properties and associations along those lines. There's only certain things that we can ask a landlord for under the law. We can ask for the name of the adult tenants that are going to be in the property. We can ask for the length of the lease, start and finish date of the lease. We can ask for the vehicles, information regarding their vehicles and their license plate numbers. And we can ask for proof of age if it's a 55 and over community. That's it. So requiring them to provide registration with the city of Scottsdale and the assessor's office as a rental property, we cannot do. But you can, on the flip side, if you want to, you can check the Maricopa County Assessor's Office to see if they are a rental property. It's very easy to do. Just Google Maricopa County Assessor's Office, type in the address. The address will come up. It'll list right there on the website if it's a rental property or not. You also can check with the city of Scottsdale. The website has a listing of the rental properties on a map. You can call the Neighborhood Services Department of the City of Scottsdale to find out more information on that. Next question, number 37 from an owner. It looks like we need to do a board member recall. Can you explain the criteria? And if we gather the signatures at association-sponsored events or at association community pools, can we do that? Okay, so again, we just shared this cheat sheet on the top 10 things under Arizona law. Number 6 is removal of directors. Short answer for you is there is a process that you have to follow under state law. I know your association is very large. I see the name here for your association. So I'm going to go over the process for larger associations, 1,000 or more units or lots. You need to submit a petition to the board with signatures of owners that are at least 10% of the owners in your association. If you are a smaller association, which is less than 1,000 votes, it's going to be 25% of the owners would need to sign it. Once that petition is submitted, the board counts the signatures and make sure that they're not delinquent, make sure that they're the record owners. If you have the requisite number that you need, then the board has to call a special meeting of the membership to remove the board members. At that meeting, there's a 20% quorum that's required of the entire membership, and there needs to be a majority of the quorum present in person or by absentee ballot at the meeting would need to vote to remove the directors from office. Question number 38 from a board member. Is there a cap on transfer fees? So we have a great cheat sheet on disclosure fees and transfer fees, which we're sharing with you right now on Zoom and Facebook Live. I encourage you to take a peek at it. So I guess this is kind of a loaded question because a transfer fee is very specifically defined under state law, under Arizona law. And there are specific requirements that you have to follow in order to charge a transfer fee, or what they also refer to as a capital contribution fee. So as long as those requirements are met, and just quickly, they would be like, it has to be in the CC&Rs, the purpose of the money, how it's going to be used, has to be listed, it has to go to the association, it has to touch and concern the land. There isn't a cap. I mean, I've seen transfer fees that are as low as $500 all the way up to $40,000 for a really upscale association in Flagstaff. So there isn't a cap under the law, but you have to set it up right for you to be able to collect it. Okay, next question, number 39 from an owner. In January 2024, the management company for the association provided all the residents the board meeting schedule for the year via email. The first board meeting occurred in March, and no notification was sent out to the residents 24 hours prior to the meeting. A resident attending the board meeting brought to the board's attention that no notification was sent to the residents regarding the March meeting. A board member said, "We were notified because the email notice sent in January with the annual schedule. Does this violate the open meeting law?" So setting out a schedule at the beginning of the year by email, as long as the dates and times and place aren't changing, is sufficient under the law to meet the requirements of the open meeting law. Okay, next question, number 40, from a board member. What are the ARS requirements to hold a recall of a board member? Okay, this is like, I don't want to go too deep on this again because this is our third question on this. There must be a lot of turmoil right now in associations. So I'm sharing the cheat sheet again with you. It's the top 10 cheat sheet, number 6. That gives you a very deep dive on what you need to recall a board member. You put in here, particularly as it relates to advance notice. I guess I would have to say, advance notice. I think what you're saying is how much notice do we have to give to the membership of the meeting to remove the directors? So it's the same notice that we would give for an annual meeting. So it's not less than 10, not more than 50 days in advance of the meeting would be the notice, the ballot notice. Okay, next question is from a manager. Great to see you here today. Who is responsible for setting the agenda for a board meeting? I have a community that all board members want to have input on the agenda, which is fine if the board wants to run it that way. But some of them disagree, and I believe it's just the board president and any agenda item that need to be submitted to the board president to be reviewed for the agenda, for addition to the agenda. all reasonable requests should be considered. This is a really good question. How do we set up the agenda for a regular board meeting? Typically, the manager does the first draft and runs it by the board president. The other board members aren't really that involved, and they aren't trying to add things to the agenda, et cetera. Sometimes when we see this, there might be some level of dysfunction on the board, whether it's with the president or whether it's with the other board members, I don't know. But when we're fighting about the agenda, to me, that's a warning sign, smoke signal. There's probably some dysfunction on this board. Okay, a couple ways to handle this. In most associations, I'm assuming this is not a problem. But if you are having a problem on what goes on the agenda, what doesn't go on the agenda, here's what I recommend. In order for something to be added to the agenda, a majority of the directors would have to agree it needs to be added to the agenda. Maybe you lower that and say 2 board members would have to agree or 3 board members would have to agree. Typically, the president and the manager set the agenda. If another board member wants something added, I would say try to get a consensus and get a couple other board members to agree with you, and then it should be added. And again, this is just practical advice, right? There's nothing in the law that talks about this. If you've got a Lone Ranger board member who can't get another board member to ask to approve to have something added to the agenda, what I would suggest to that board member, if they're listening in, it's okay for you to talk during the homeowner forum. You're a homeowner too. And you can say, I would like this topic to be addressed at this meeting today and see what the board says. So during the homeowner forum, you just take your board member hat off, walk over to the mic if it's live or if it's on Zoom, raise your hand and just say whatever the issue is that you want to have heard. Next question, number 42 from a board member. Can a board member who just voted off the board request to review all documents related to the vote, including all the ballots? I realize the vote is at an open meeting, but providing all this information will allow this board member to know not only what the account was, which was reported at the meeting, but also who voted for which candidate at the meeting. Okay, so what you are asking for, so a board member who's just voted off the board is now just considered a former board member and a homeowner. So as a homeowner, you can make a records request to see the ballots for the meeting. You certainly have a right to review those. Just put it in writing, make that request, and the board should provide that information to you. I don't think your board has secret ballots, but if they were secret ballots, you wouldn't be able to determine who voted for who. But I'm guessing it's not secret ballots. So the board, even though they're probably going to be reluctant because they're going to say, well, people won't want us to know how they voted their ballots. The reality of the situation is the ballot is a book and record of the association, and it's something that has to be disclosed to a requesting owner if they request to see it under the books and records request of the law. Okay, next question. Our bylaws indicate that board members will be elected to 3 terms. At the annual meeting and the election approaches, they have suggested a convoluted plan to extend their time on the board beyond 3 years. Is this action appropriate or possible? So I guess I'm and I know this is a former board member. Great to see you here today. So they're elected to, I think it should be 3-year terms is how the question should read. So you're only elected to a 3-year term, and they have a plan to extend beyond the 3 years. So I have seen this. I mean, I will tell you the truth. I have seen this before where maybe there's an open position on the board, a vacancy, and the board member resigns from their position, which maybe their term was going to be up. And then they get appointed to this other term that, is just starting, maybe has 2 years left on it. So, I mean, I don't usually advise doing something like that, but there might be like a legal loophole way to do it. But to me, it just doesn't go along with the transparency and the nature of how associations should be run. So I really try to shy boards away from doing things like that. Not saying it's illegal. I'm just saying I don't know what their convoluted plan is. I'd have to hear more about it. But I don't like it when I see that because I think it causes distrust among the membership. Okay, question number 44. What is your opinion on using the realtor fact sheet to increase reserve funds by adding a 1% buy-in to the HOA? Well, I think this kind of goes back to our take a peek at our cheat sheet on the disclosure fee versus transfer fee. I feel that if you're going to charge a 1% buy-in, it really needs to be in the CC&Rs, and it's probably going to be considered, like a transfer fee or a capital contribution fee, and you need to follow the law. You can't just do it without having it be in compliance with the law and in your documents. Okay, question number 45. From a homeowner. As a homeowner, am I allowed to know how the money is spent? The HOA has moved from self-operating to a management company in the last year. If my projections are correct, we will be bankrupt in less than 6 years. No money is being deposited into reserves. Money is being drawn out for various unbudgeted projects. So yes, as a homeowner, you should put a records request in writing to the board and to the management company and say, I'm a homeowner. I would like to see the following records. Ask for a copy of the check register. Ask for a copy of the bank statements. Ask for a copy of the year-to-date budget for the association. Ask for a copy of the financial statement for the association. And that should give you a good start in terms of how the money is being spent. Question number 46. We only have 3 board members, and I am only on the board less than 2 years. The other 2 board members are less willing to object to inappropriate architectural requests, and I'm frustrated because they're outvoting me. Any advice to educate them on our style of homes? Well, a couple things. I think you should give them our cheat sheet on architectural committees so that they understand the requirements of serving on an architectural committee. And that would be my first suggestion. The next suggestion is make sure that they understand that they have a responsibility to uphold CC&Rs. Maybe this is a time where we have a boot camp and come in and talk about what it means to be on the board and what fiduciary responsibility is, including the duty of care. Okay, next question. Let's see. Number 48 is, if ballots are faxed in, must it be from each unit owner or can it be done by one person helping possible mobility? Okay. Let me see this again. If ballots are faxed in, must it be from each unit owner or can it be done by one person helping possible mobility impaired individuals? So it just depends on how the election is set up, right? Like how ballots can be returned. It's kind of unusual that ballots are faxed in. So I'd have to look at the situation, here, but what does a ballot say in terms of how can ballots be returned to the association for this vote? And then after I looked at that, then I would look at, is the ballot returned in that fashion? Okay, next question, number 49. Can the board say that we are not allowed to speak about open fines or grievances during the meetings? They will tell us we can't talk about any concerns on our personal homes and tell us they don't have to answer anything we bring up and won't allow us to email or call the board, even though the homeowners guides say we can call them. So we aren't being heard at all. They even mute us if they don't want to hear what we have to say. Okay, a couple things here. So the way that the open meeting law is written is that if you have a violation, then you're being heard on it, meaning like, let's say that this is your opportunity to be heard on a fine that's been levied against you. As a homeowner, you can ask to have that fine or grievance heard during the open portion of the meeting. So just know that you have that right. You can look at our open meetings cheat sheet to find out more specifics on that. But if you're asking about during my opportunity to be heard, that's part of the fine process. If I want my grievance to be heard in an open meeting and not an executive session, you have a right to ask for that to be done. What your board really should be doing is having a homeowner forum at the beginning of the meeting where you have an opportunity to talk. That would be what I would suggest. And then if you have anything that you want to talk about as a homeowner, then you have a minute or whatever, 45 seconds, 2 minutes, whatever the time period that they give you to talk about your concerns. If they don't allow you to do that, which they don't have to have that homeowner forum, although I really recommend it, I think it's a good idea, I would just start documenting your concerns in writing to the board so that there's a paper trail about things that you're concerned about. Next question from a board member. Our CC&Rs prohibit RV parking behind RV gates and regulates parking on streets to prevent RVs there too. If our association decides to vote this year on removing street parking regulations, we possibly end up in a situation where RVs can be parked on streets, but cannot be parked behind RV gates. Is that accurate? I think it's going to really depend on what your city, town, or municipality you live in Like, do they allow RVs to be parked on the street? So check with the city, town, or municipality because, depending on whether or not, when we're talking about this new law that's going to be going into effect in 2026, that talks about streets that are owned, planned communities, streets that are owned by the city or dedicated to the public or to the city, town, or municipality, and the association not being able to regulate parking on those streets if we don't take certain action by 2026, getting a vote of membership to continue to extend, our parking regulations and letting the board enforce them. So if you're one of those associations where we lose the right to regulate on-street parking in a planned community where the streets are dedicated to the public or to the city, is it possible that people can park RVs on the street then? Well, check with your city, town, or municipality, see what their restrictions are on that. It is possible. That is something that could happen. And you said you don't think this is a good idea. I agree. This law is problematic. I agree. Last two questions. Number 51 from a board member. How does a board member respond to a code of conduct violation from another board member? Okay, so I don't know the facts here. Apparently you have a code of conduct in your board, which is a good idea to keep everybody in check and following the fiduciary responsibilities, the law, and your documents. So one board member claims another board member is violating the code of conduct. I would recommend that you get your attorney involved and talk about this because it seems like there's some dysfunction on this board. I would recommend that you either have an executive session with your attorney where everybody's present. We talk about the issue. If you don't want to do that, then I guess duke it out between the two board members, right? One person raises an issue. The other person should politely and respectfully give their response in an open board meeting. Last question for today. So we made pretty good time considering 52 questions, an hour and 36 minutes. Last question from an association president. Assume a husband and wife jointly own a single lot and the HOA has 3 board positions. Can both serve on the association board or committee, thus giving the single lot majority control at a board or committee level? It depends on what your documents say, but typically the documents will say that you have to be an owner to serve on the board or sometimes to serve on the committee. Is it a good idea to have a husband and wife serving on the board together and be a majority? No, it's not. And I don't recommend it. Is it possible? It depends on what your documents say. It is probably possible to do that. But again, I don't recommend this. Okay, concluding remarks for today. Thanks so much for being here today. We had a great turnout, 83 people on Zoom with us at one time. And on Facebook, we had over 20 live viewers. So that's awesome. I mean, that's over 100 people here today just listening to us answer our free questions. Remember that if you ever want to go back and listen to the answers, you can go to our Facebook page from Mulcahy Law Firm. And this video is right there. You can click on it and find questions and answers to those questions at any time. So thanks so much for being here today. On Tuesday, April 16th, we're going to be conducting class number 4 of our 2024 Virtual HOA Academy. This is going to be a really good class because we're going to be talking about navigating stormy waters in an association. So how do we handle difficult people and difficult situations in HOAs and condominiums? This is a class you won't want to miss. If your association is having trouble, is in turmoil, has problems, we're going to give you a lot of suggestions on how you can make it a more positive experience and solve those problems. In this session, it's going to be a great class, so I hope you join us. And don't forget also that next month's virtual First Friday event is going to take place on Friday, May 3rd at 9:00 a.m. So we hope you'll join us live then to answer questions in May. Hope everybody has a great weekend. Happy Friday and good luck with the Final 4 coming up in Arizona. I know it's a busy time for Arizona. Great opportunity economically for our cities to benefit from that, and happy to have all those residents and visitors here visiting, cheering on for all those basketball games. So take care, everybody. Have a great weekend. Thanks for being here today. Bye.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review.